Brand new details in the case of an alleged cult leader. We have stayed on top of the story for you from the start. Now a DeKalb County judge has denied bond for Eligio Bishop as he faces several charges.
Above listed case and has been held without a bond since that date. Mr. Bishop poses no significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. Mr. Bishop poses no significant threat of danger to any person, to the community, or to any property in the community. Mr. Bishop poses no significant risk of committing any felony pending trial, nor does he pose a significant risk of intimidating witnesses or otherwise obstruct the administration of justice. Wherefore, Mr. Bishop respectfully requests that this court reduce his bond to a reasonable amount. Respectfully submitted this 30th day of November 2022. The next motion is the state's motion for discovery. Motion to inspect and copy physical evidence. Comes now the state, and pursuant to OCGA Section 1716-4, and demands that the defendant produce for the purpose of inspection, copying, or photographing the following: books, papers, documents, photographs, tangible objects, audio and videotapes, films and recordings or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, custody, or control of the defendant. The state further demands that the defendant comply with the above demand within 10 days of the state's compliance with the defendant's motion to inspect, but no less than 5 days prior to trial. Upon the failure of the defendant to comply, the state requests that the defendant be prohibited from introducing the evidence at trial. Motion for scientific reports. Comes now the state, and pursuant to OCGA Section 1716.4, and demands that the defendant produce for the purpose of inspecting and copying or photographing any results or reports of physical or mental examinations and of scientific tests or experiments, including a summary of the basis for the expert opinion rendered in the report or copies thereof within the possession or control of the defendant. The state has, at or before the filing of this motion, provided the discoverable material in its file to the defendant. The state demands that the defendant comply within 10 days with the above motion. Upon failure of the defendant to comply, the state requests that the defendant be prohibited from introducing the evidence at trial. Motion for witness statements. Along those same lines, state demands that the defendant or the defendant's counsel thus relates to the subject matter concerning the testimony of that witness. The state further demands that the defendant comply with this demand no later than 10 days prior to trial or at the time of any pretrial evidentiary hearing other than a bond hearing. Upon the failure of the defendant to comply, the state requests that the defendant be prohibited from calling that witness at trial. Motion for list of witnesses and witness information. Comes now the state, and pursuant to OCGA Section 17-16-8, and demands that the defendant produce the names, current locations, dates of birth, social security numbers, and telephone numbers of the defendant's witnesses. The state has, at or before the filing of this motion, provided the discoverable material in its file to the defendant. The state demands that the defendant comply within 10 days with the above motion. Upon the failure of the defendant to comply, the state requests that the defendant be prohibited from calling that witness at trial. Furthermore, the state demands disclosure of any evidence the defendant intends to use at trial, including the name of any expert witness and that witness's report containing their opinion and the basis for that opinion. Request for reimbursement. The state hereby moves that this court order that the defendant reimburse the state for the actual cost incurred in providing documents and other material to the defendant as part of its compliance with the defendant's motions for discovery. Notice of continuing duty to comply. Under OCGA 17-16-1, the defendant's duty to comply with the foregoing is continuing if at any time the defendant discovers additional evidence or material previously requested or ordered which is subject to discovery or inspection under this article, the defendant shall promptly notify the state of the existence of the additional evidence or material and make this additional evidence or material available as provided in this article. Notice of aggravation of punishment. The defendant's GCIC is available in the state's file for review. Notice is hereby given under OCGA 17-10-2, 17-10-7, and 17-10-6.1 that any criminal conduct or conviction described in the police reports or any other discovery materials will be used by the state in aggravation of punishment. These convictions may also be used for impeachment purposes if allowed, should the defendant elect to testify. Notice regarding physical evidence. The following items are available for inspection and/or copying in the office of the district attorney upon election by the defendant to proceed under the provisions of OCGA 17-16-1, all physical evidence, including but not limited to controlled substances and any and all photographs and videos are available for inspection after a written request at the office of the district attorney, the police department, and/or the Georgia Bureau of Investigation Crime Lab, wherever such evidence may be located pursuant to Georgia law. Audio and video recordings. If the provisions of OCGA 17-16-1 have been properly invoked, and if any audio tape or videotape recordings are described in the police report or other discovery materials, the district attorney's office hereby makes the materials available to the defense. They may be reviewed in the district attorney's office by scheduling an appointment at a mutually agreeable time in normal working hours. Copies of such materials can be obtained by providing a blank tape to the district attorney's office with a written request specifying the defendant's name, the case number, and a specific description of the materials to be copied. Copies will be available 5 working days after the request is submitted. Respectfully submitted this 23rd day of November 2022, Tabitha Pesnino. Supplemental motion in, I'm not sure what that word is, but LIMINE, to exclude evidence that is inadmissible under the Rape Shield statute. Comes now, the state of Georgia, by and through the District Attorney's Stone Mountain Judicial Circuit, and moves this honorable court in limine, oh my goodness, somebody please correct me, to exclude evidence by the defense that is inadmissible under the provisions of OCGA 24-4-4, hereinafter referred to as the Rape Shield statute. Specifically, the state seeks to exclude the defense from attempting to introduce any testimony, evidence, cross-examination, or questions designed to elicit testimony concerning the past sexual behaviors, including reputation for promiscuity, non-chastity, etc., of J.N. The state additionally submits that any violation of the Rape Shield statute, even unintentional or inadvertent one, would be highly prejudicial, and while the state may have the right for a mistrial for such a violation, and that would involve substantial trauma to the victim and judicial waste, the state therefore submits that any